All right, we'll go ahead and get started. This is Chris Bear with Castle Wealth Group at one of my satellite offices. So we have some weird lighting going on. But I want to thank everyone for joining us on our weekly wisdom webinar where we just go over whatever legal, financial, and tax questions you may have. And we have a few that have been submitted already. And we always like start with a positive focus, just something positive that's happened over the last week or so. And for me, my son, who's 13, he just started he's going into high school freshman year next year, but they started like high school soccer. So they have like strength and conditioning, running some practices and stuff. And so he's pretty excited with that. But with that, I'll go ahead and share my screen and we'll go ahead and get started. And again, if you do have a legal, financial, tax question you want me to take a shot at answering on the fly, just feel free to go ahead and shoot it over in the Q&A. And let's see. My first time attending your webinar, so I'm not sure if you have a specific topic each week, so I just plan on listening. Yeah, typically I don't have a specific topic. Really, this is just questions people have submitted either ahead of time or while I'm on the webinar. So it's not like there's a PowerPoint each week or anything like that. It's really like, think of it like my dad was a professor for 47 years, so think of it as kind of open office hours. Whereas a certified law attorney, certified financial planner, helping people plan retirements, legacy planning, legal, financial, and tax planning, just kind of what questions or thoughts they have, or maybe something they've seen, and I just share my thoughts on that. So, first question here is, and I'm sharing my screen. Let me read it. So we plan on leaving our grandchildren part of our mutual funds and part of our IRA in a trust for their benefit. When we pass away and this trust is funded, it becomes irrevocable, I assume. That's correct. So even a revocable living trust while you're alive and well, or even like one of our irrevocable trusts that you can make changes to that act as an asset protection trust, once you pass away, they truly become irrevocable. Like they lock down, no more changes can be made. That's what builds in the protections for the beneficiaries. So the questions are, will this irrevocable trust have the same protections as a castle trust? So in reality, most people set up one of two types of trust. One would be a revocable living trust while you're alive that avoids probate and can control the distribution, including building in this legacy provisions for the kids. So like if you had three kids, your one trust could split into three separate shares, one share for each kid. Each kid could then take their share in a separate share trust, really protecting that legacy. And what this does for the kids is it protects them from things like divorce. So if they were to get divorced, whatever they keep in the trust is protected, protects them from creditors. If they were to get sued for whatever reason, whatever's in the trust is protected. And then if they were to pass away, the money stays in the bloodline. So it flows down to your grandchildren or goes to your other children. And this is only available through setting up a trust. You can't do this through beneficiary designations. And not just any type of trust. Really what we're talking about in our office is what we call a legacy trust, which is a form of revocable living trust. So the question is, will these legacy provisions have the same protections as a castle trust? Really, the answer, big picture, is yes. Yes. So we're protecting from divorces, creditors, bankruptcies, and we can add in long-term care costs, more specifically that nursing home Medicaid spend down. Because the other type of trust is what we call in our office a castle trust, and it's a form of asset protection trust. And so this, for you, avoids probate, protects the kids, and most importantly, protects you from lawsuits, creditors, and the devastating cost of nursing home care, which can run $10,000 to $15,000 a month. So second follow-up question is, do we need to set up a castle trust for them and fund it as our TOD? The answer is no. So if we have a revocable living trust that builds in these legacy provisions, then each of those separate shared trusts are basically like a mini castle trust in a sense. So they don't have to set up their own separate castle trusts unless they want to do it for their other assets. But whatever they inherit from you from the legacy trust is going to be protected from divorces, creditors, bankruptcies, et cetera. So So let me see any questions on that. Brokerage trust for Roth. Selling condo. Okay, I'll get to those questions in a second. So hopefully that's helpful. Well, let me get to another question that was submitted ahead of time. Let me pull it up here. Hit a couple buttons. And where did it go? I had it right before I logged in. Here we go. I have trust with you. Thank you. All right, here's the next question. So let me bring it over. Then let me share my screen again. All right, here's the next question. I have a question for next. All right, does a 10-year withdrawal rule still apply if Roth IRAs are left to our designated beneficiaries on a legacy trust set up by us? If yes, then those assets after withdrawal from the Roth are no longer protected. Okay. So here's the thing. So in 2019, and it became effective January 1st, 2020, passed the Secure Act. And the big thing with the Secure Act is your required minimum distribution age went from 70 and a half. The year you have to take money out of the any type of pre-tax accounts like IRAs, 401ks, not Roth, IRAs, traditional IRAs, 401ks, pushed it back to 72, and then Secure Act 2.0 pushed it back to 73 or 75, depending on your age. That's not the real reason they passed the Secure Act. The real reason they passed the Secure Act is prior, kids or beneficiaries could stretch the taxes over their lifetime. But you would have RMDs, required minimum distribution. So they would have to take out a little bit each year. And the same with Roths. So not only traditional IRAs where they'd have to pay tax, but they would have to take out of the Roth, they would have an RMD. It was not taxed, okay? The Roth is tax-free, but they still would have to take out these RMDs over their lifetime. And it was, excuse me, based on an actuarial table. So post-Secure Act, what happens is now everything has to be taken out of the IRAs or Roth within 10 years. If it's taken out of a pre-tax account, they have to pay the tax. If it's a Roth, it has to come out, but it has to be tax-free. But that said, think of a trust kind of like a box. Inside of that trust could be a Roth. And so if you're forced to take the money out of the Roth, the money can still stay in the trust, but now instead of a trust Roth, it's a trust brokerage account. Okay. So it still would have the legacy provisions. So think of the trust kind of like a box. We could have a Roth in there. We could have a brokerage account. All we have to do is take the money out of the Roth and put it into the brokerage account. So we still get the benefits. We just have to take it out of the Roth. All right. So hopefully that was helpful. So yes, even with the legacy trust, even post Secure Act, you still get the benefits of the legacy trust. All right, next question. I'm not sure if I fully understand this. Brokerage trust for Roth. Is there a 5-year look back period? So there's two potential 5-year look back periods we could be talking about. One would be with regards to the Roth. When you move money into a Roth, you want to wait 5 years, and there's certain exceptions. Otherwise, you'd have to pay some tax on the growth. The other 5-year look back period would be like if we set up a Castle Trust, protecting against Medicaid, which has its own 5-year look back period. Either way, well, I guess that's not really what we're talking about. So yeah, if we're just putting money into a Roth, the idea is that you don't take it out within 5 years. Otherwise, you might pay some taxes on the growth. All right. Another one. And this is the last one I have. So if you do have any other, is everyone seeing I just see a black screen. It should be showing. If not, this is recorded. And I have someone that puts together like nice graphics and everything for it. So, all right, all right. So selling my condo, I bought it for 300,000, sell for 450, have to pay off the mortgage, commissions, etc., maybe 100,000. So it's my capital gains 150. What is the best thing to do with the proceeds? It's more of a tax question for a CPA. But yeah, my feeling is that you'd be able to deduct any expenses and stuff you have from the sale. On its face, the capital gains would be 150. There are certain exceptions if it's your primary residence. Like, for example, a single individual, you have a $250,000 exemption, if I'm not mistaken. A married couple, 500,000, if I'm not mistaken. So chances are you might not have any capital gains at all. And if you do, I would say it'd probably be reduced for your expenses, which would be 50,000. But again, I think it's probably going to fall depending on your situation within an exemption. So you probably would not have any capital gains. Best thing to do with the proceeds, that really depends really on what you want to do with the money. I always look at time horizons. If you're not really sure, one of the best things you can do right now is what's called a high yield savings account. Like right now, we have high yield savings accounts that are completely liquid at like 5%, where that money, you just link it to your checking account, you can move money in and out. And if you want more information, just shoot me an email on that. I have a trust, sharing my desktop. It should be shared. And again, if you can't see it for whatever reason, I have, these are always recorded and show up on our YouTube channel. And so, I have someone that like puts together the graphics and stuff. All right, last one I have here. Whoops. Let me try this again. So comment is, we currently have Grantors Trust. Is this the same as a legacy trust? Basically, any trust that we do in our office, unless you have an estate tax issue, which is over 12 million or 13, someone's saying, I do see the desktop. So might be where you have to click around in Zoom and it's something. Yeah, a couple people saying or they can see the desktop. So thank you. So the question is, we currently have a grantor trust. Is that the same thing as a legacy trust? Well, basically every trust we do is what's called a grantor trust. A grantor trust is basically just in your own social security number, meaning you do not have to get a tax ID number, meaning you don't have to file for a separate tax ID. You pay taxes the way you normally do. Even our asset protection trusts are grantor trusts. Really, the only time we're doing non-grantor trusts, we'd have to have a reason to do that. That has its own tax ID number. That would be more for estate tax purposes or very specific situations. But to answer your question, yours is a grantor trust, and yours is also what we call a legacy trust. So yeah, answered that, answered that, answered that. All right. Well, with that, that is all I have this week. Again, if you do have questions or you want something to cover, maybe not even just a specific question, but some concept or big picture thing that you want us to cover, just let us know. If we don't have anything submitted, that's when I'll go ahead and kind of pick a topic or pick something that's going on in the world. But I always do appreciate the questions. So with that, make it a great week. Thank you. Take care.